Our next speaker will be Professor Bill from National University of Singapore. Professor Bill has written extensively in this area, and I find one of his articles very interesting and very significant for the current position of Hong Kong that relates to a reservation under Article 95. I think that's a topic Professor Bill is going to talk about. So I will just hand it over to Professor Bill.
Thank you very much. I'm very pleased to be with you, and I'm very, very happy to have this opportunity. And I want to thank you, Xiao, and thank the City University as well as the Center for inviting me. When I look at the consultation paper that was prepared by the government of Hong Kong, and I'm sure Mr. Wong, you had a role to play in that, I must say that this is an excellent paper. I really was quite impressed by the paper that was presented. And I'm therefore wondering whether I need even to say very much, because the paper actually puts quite clearly the dilemmas and the difficulty with respect to Article 95. But nonetheless, let me add a few things to what was in the paper and explain my own views, why I think, and I guess I should go back to the first page, that it would be a mistake to have a reservation 95. Now, I am talking from an academic point of view, and I will talk a little bit about from experience as well in Singapore, but also my experience as an arbitrator. But the situation, of course, is also a political choice, and on that I have very few comments. I do realize that China has a 95 reservation, and it might be difficult to justify Hong Kong not having that reservation since the mainland China has the reservation. So I will leave the politics to people of Hong Kong. But let me nonetheless say why in the abstract, it's not a good idea for a country, and I think for Hong Kong, to have this reservation. Let me explain to you what I will talk about today. Mainly I will, and everyone is familiar, so very quickly go over the application of the CISG and the reservation, and point out the conflicts of law problems that are caused by Article 95, and they are, in fact, explained quite well in the consultation paper, but I will try to show why that is not a good thing for Hong Kong. And then I will also give two other reasons, there are many more, but two other reasons why I think Article 95 the reservation should not be made. And I will talk briefly of the Singapore experience with 95 and with the CISG. Okay, so everybody is familiar, I guess, here with Article 1, but nonetheless, let me say that the convention applies when the states are, the parties at a place of business in different states, and these states are contracting states. That's 11A, and this will apply to Hong Kong. There's no reservation to 11A in the convention, so you have to, if you sign on the convention, you have to accept 11A. Now, 11A is not a choice of law situation. It's really applies, the parties, of course, under Article 6 can decide not to have the convention, but this is an application of convention by rules of private international law that are imposed outside of the choice of the parties, right? The real one on the choice of law that allows the choice of law by the parties is 11B, when the rules of private international law lead to the application of the law of a contracting state, and that includes choice of law by the parties. And therefore, 11B is the way in which parties normally could choose the law of a place. Now, in the context of Hong Kong, it might be useful to remind ourselves of Article 93. I won't read the whole thing, but basically, if a country has different units that have different systems of law, in a federation, for example, Canada is a case like that, but China, Macau, Hong Kong, and mainland China have different systems of law, then that country can make a declaration that the CISG applied to part of the country, but not the other part. I'm saying, and that would mean also with respect to Article 1, that the place of business, if the place of business is in Hong Kong, even though China is a party, then for the purpose of the convention in 11A and 11B, it is not a party to the convention, right? Okay, it's a presumption that because the CISG doesn't apply in that territory, it is as if it was not a contracting state. I say all this because it would allow, this 93 provision would allow Hong Kong to not make the 95 reservation, even though mainland China has made a reservation. There's a precedent for that. It's in my country of origin, Canada. For many years, British Columbia, for a few years, British Columbia had made a 95 reservation, and Canada had made a declaration that in British Columbia, 11B doesn't apply, but in the rest of Canada, 11B does apply. British Columbia saw the light eventually and withdrew the reservation, but it has been done that a reservation under 95 was applicable to only part of the territory. But of course, it's also a political issue, and I'm not going to speak about that. But if Hong Kong were to adopt the CISG without a reservation, of course, a buyer in Hong Kong who would want to fight the CISG to apply could choose Hong Kong law, even if the seller is in Indonesia, which would not be possible if the reservation is made. The reservation, everybody knows it, but I think it's important to look at the very wording of the reservation to understand the conflicts issues that might arise. Any state may declare that it will not be bound by 11B. Okay? It's a state that won't be bound, right? And the draft bill is done to reflect exactly 11B, and that's perfectly fine for that objective. And it says that basically the convention would only apply the part 11A rather than 11B, and therefore it would read in this fashion. So if an Indonesian party, and just to inform you, Indonesia is not a party to the CISG, so I'll use Indonesia as an example and Malaysia as an example of non-parties, then they choose Hong Kong law as a governing law. If Hong Kong make the reservation, it will be Hong Kong law without the CISG. That's the effect of not having 11B. Now everybody here knows that. The net effect of that reservation, I think it's important to understand. I mean, everybody understand what a reservation does, but what does it mean exactly? The net effect is to limit parties' autonomy, to limit the choice that of the governing law. The parties cannot choose, at least this is the goal of the reservation. It seeks to prevent the parties from using the CISG unless both parties are in territories that are parties to the CISG, right? That's what it tries to do. In Hong Kong, what it would mean is that Hong Kong parties could not use the CISG with Hong Kong by choosing Hong Kong law and with Hong Kong law to complement the CISG unless the other party to the contract of sale is also from a country that is a CISG party. Okay. Now, for Hong Kong as a free market economy and that has a liberal approach to choices of law, to this outsider, at least, it looks quite counterintuitive to what one imagined of Hong Kong as a liberal place in terms of law. This trend in international, as you will know, is let parties choose their contract law. But this reservation goes against that trend, and I think that's not a good thing. Now, sometimes people say, well, it makes sense to have this reservation. It's reciprocity. That's the reason why the United States and China has made that reservation originally. But I think this is wrong. We shouldn't look at it as a matter of reciprocity. First of all, reciprocity makes sense in public international law. But why should it matter in private law matter, choice of law matters, which is not a public international? Of course, state-to-state relationship, you want reciprocity. But we're not talking of state-to-state. We're talking private parties and how to arrange their private international, if you wish, their choice of law. And therefore, I don't think it makes sense to look at 95 and justify it as a reciprocity provision. And if Hong Kong wants to continue to be a hub for legal services, why put restrictions on the law that people can use when they bring the dispute to Hong Kong for resolution? The reservation prevents people from non-CISG country from choosing the CISG through Hong Kong law. And this is the problem. It also prevents Hong Kong business from using the CISG if they trade with a party who is not a CISG country. So it really limits the choice. This, just repeating myself here, it just goes against party autonomy, and I don't think that's good for Hong Kong as a dispute resolution hub. Right? I'm from Singapore, so Of course, we're competing for dispute resolution, but as a friend of Hong Kong, I really don't think it's a good thing. Now, what are the conflicts problems created by Article 95? One of the main arguments against this reservation is the uncertainty that it creates in terms of conflict of law, private international law. And the problem, actually, I don't know what I need to say very much about it because it's quite well explained in Annex 2.2 of the consultation paper. And there are 4 scenarios that are mentioned there, and I'm going to look at them very quickly. There are 2 scenarios that are really not complicated. If the form is in a contracting state that is bound by the CISG, the chosen law is a law of a contracting state that is bound to the CISG will apply. But to 1.1b, the CISG will apply because of 1.1b. Now, let's say parties are from Indonesia and Malaysia, both of which are not party to CISG, and they choose the law of the Republic of Korea in front of Japanese courts, right? No problem because both Japan and Korea are bound by 1.1b, and therefore the CISG will apply. The second easy case is a contracting state which is not bound by 1.1b, is the state of the forum, the court. The chosen law is also the law of a state that is not bound by 1.1b. Then the CISG doesn't apply because there's no 1.1b. Let's assume, for example, that Hong Kong adopts the CISG with an Article 95 reservation and inform you that Singapore also had that same reservation. So the parties are from Indonesia and Malaysia, and they choose Singapore law in front of Hong Kong court. No problem. The CISG doesn't apply. Now, by the way, all of these scenario at the top, the thing in the table, is taken directly from the consultation paper. So everything is in there. So the government of Hong Kong did a very good job. And then if you look at the third case, this is the first difficult case. A contracting state which is bound by the Article 1.1b is the forum, okay? And the law comes from the contracting state which is not bound to 1.1b. So what happens then? So if Hong Kong adopts the CISG with the reservation, and the parties are from Hong Kong and Malaysia, and they choose Hong Kong law in front of Australian courts, right? Now, Hong Kong has made a reservation, but let's look at the reservation. It said a state may declare that it will not be bound by 1.1b. Now, the state here is China's declaration that Hong Kong is not bound by 1.1b. That declaration is not binding on Australia. It's not binding on Australian courts. The court, right, is not binding on them. So the courts are bound by 1.1b because Australia doesn't have that reservation. So in principle, they should apply the CISG. Now, this is a bit bizarre because Hong Kong law has rejected the CISG, but because they go to a different court, right? So that creates, this is a prevailing view. Others have argued that they shouldn't do that. I've tried to argue it shouldn't do that, actually. But nonetheless, it brings uncertainty. And it encourages also forum shopping. In fact, if you want the CISG to be complemented by Hong Kong law, for matters not governed by the CISG, right? Your only choice is to avoid Hong Kong courts. You have to get out of Hong Kong, go to another forum. I can't see how this is good for Hong Kong. Now, some argue that this scenario, I have argued that in this scenario, you should say really frankly, yes, I know I'm bound by 1.1b, but if I look at rules of private international and I look back at Hong Kong, they don't want the CISG, so I shouldn't apply it. But it leaves uncertainty. The last case is where the forum is in a country that is not bound by 1.1b, and the contracting state of the law comes from a contracting that is bound by 1.1b. So assume Hong Kong adopts the CISG with the reservation. Parties are from Hong Kong and Malaysia, and they choose the law of Australia in front of Hong Kong court. Hong Kong court is not bound by 1.1b. It doesn't have, therefore, to apply the CISG when applying Australian law. But the court is not bound, but doesn't mean it cannot do that, and could follow its own rules of private international law and say, well, they really meant the CISG. But again, a bit of uncertainty there. Now, I don't think the consultation paper went into what happens in arbitration. But this is also a bit of a problem. The Article 95 provision says that the state is not bound by 1.1b. The arbitral tribunal is not a state entity, even if it sits in a seat in Hong Kong or elsewhere. It's not a state entity and could disregard the reservation, should probably. It will bring uncertainty as well. And if the parties have not made a choice of law under many arbitral rules these days, the tribunal is free to choose the most appropriate law, that is the voie directe in private international law. And the effect of that is that they could apply this Hong Kong with the CISG without, while ignoring the reservation. So all of this brings a lot of uncertainty, which is the main argument why I think Article 95 reservation is not good. Other reasons? First, reciprocity was never the reason why 95 was introduced in the first time. If you go to the legislative history, if you wish, of the travaux préparatoires of the article of the CIG, including what was said about Article 95, it was introduced by Czechoslovakia, at the time still one country, and the purpose of it was to allow socialist country to preserve their special law for foreign trade, which was different from trade within the country. So they said, if we accept the CISG and apply it to everything, there's been no place for our foreign law on trade, law of foreign trade. So please allow us to not apply the CISG when the other country is not a CISG party. So this was not the purpose originally. And it's sad that it was perceived as a reciprocity situation. No need to say, of course, that in the case of Hong Kong, there was never any socialist foreign trade law in place. And of course, the original justification for 95 is simply not there in the case of Hong Kong. But one of the most important, I think, in my view, the most important thing is put yourself in the place of a Hong Kong trader that uses a standard form contract and likes Hong Kong law. If the standard form contract says Hong Kong law applies, the result, which law applies, will be different according to which party is on the other side of the contract. If the party is from a CISG country, then the CISG will apply under 11A, right? Because Hong Kong is a CISG country and the other party is from CISG, and therefore the CISG apply. But the same contract that says Hong Kong law will not apply this, will not lead to the CISG being applicable if the other party is not from a CISG country, because 11B does not apply. So the end result is that, and I frankly have told that to people in Singapore, I understand, you have to exclude the CISG. You cannot have a standard contract where the CISG will apply if you choose, in the case of Singapore, or if you choose Hong Kong law. The only way you can have some Hong Kong law apply is to actually exclude the CISG. Otherwise, you would have to draft two separate contracts. I say that because once, if the CISG apply, you don't draft your contract exactly the same way as you would draft it under Hong Kong law without the CISG. So you would have to have two separate contracts, and of course, it leads to all kinds of problems. So I really think what will happen is that traders will systematically exclude the CISG to avoid that and to have one standard contract which will apply the Hong Kong law without the CISG. Now, talking about the Singapore experience, Singapore has been a party to the CISG since 1996, the year I arrived in Singapore to teach the CISG, right? So it has a long history. I arrived a year and started teaching the course on the CISG that year as well. Singapore did make a reservation to Article 95. By the way, my Singaporean colleagues will Alex, don't repeat that, but the consultation paper at the time was quite weak compared to what Hong Kong has written. So good job on the Hong Kong government. It was not clear that people were in the report at the time. They said, well, we don't know whether we need it. Let's adopt it and we can always drop it later. So there was no clear decision by the government of why we needed Article 95. But to this day, we do not have a single case. I checked on Wednesday, 2 days ago. We do not have a single case by a Singapore court applying the CISG. We have a few arbiter dicta, most of them by Vicky Raja when he was on the court, who seem to want people to use the CISG. So we have a judiciary that is quite interested in CISG, but there's simply no case. There are a few cases, too, I think, where the court looks at an arbitral decision and whether or not the tribunal have applied the CISG. But it's a jurisdiction issue, and it doesn't really have to do. The court does not apply the CISG. One of these cases was a case I was the arbitrator. I say this because I think there are some cases that go to arbitration in Singapore. A lot of sales cases go to arbitration, right? Very few go to court. But all the cases I've seen on the CISG in Singapore, this is a very small sample, I recognize. But when the CISG was involved, it did not involve a Singapore party. It was always non-Singapore parties that chose the CISG. So what I think is happening is that we have no case because many cases go to arbitration, maybe. I don't know, but it's not what I imagine. But also one of the main reasons, I think, is that Singapore lawyers are systematically including the CISG. And that's what I hear from everyone I talk to downtown. They don't actually know the CISG. That's part of a problem. They say, oh, well, we don't know it. Well, it's part of Singapore law. If you don't know it and you advise against it, you're negligent. As a lawyer, you're not giving good advice because you don't know what. I mean, it's okay to advise against it if you know what it says. But if you don't know what it says, it's professional misconduct, in my view. But why do they exclude it? Well, one good reason is Article 95. If you have a standard contract and the contract will lead to different things if you choose Singapore law, you have to exclude the CISG. It's not the main factor why people are excluding the CISG in Singapore. I think they're just conservative, and Michael, please forgive me, but very English in their outlook. And they don't see England having adopted the CISG, and they still follow cases from England on the Sale of Goods Act, and they think it's the best thing since sliced bread, and it's very good. The Sale of Goods Act, of course, is an excellent statute, but they don't want to change. And even though Singapore has adopted it for so long, and it might be a lesson for Hong Kong here, unless the lawyers really want it, it won't happen. And that's all I have to say. I have said more in the article that was mentioned by Xiao at the beginning of the presentation, but for now, I'm just going to thank you very much for your attention, and wish the best of luck to Hong Kong in implementing the CISG.